Huge welcome to Matt, who we're just so lucky to have you, Matt. Matt is a partner at Owen Mitchell, and he specialises in community care, healthcare and mental capacity law. And he's been involved in some whopping cases that I didn't quite appreciate, Matt, but Matt was involved in Cheshire West and Briggs. So he's got some real big accolades there to celebrate, and yeah, we're just really looking forward. So shall I hand over to you, Matt? I'm gonna you can share your screen now.
Okay.
You should be able to.
Right, hang on a sec.
Brilliant. Okay, I'll sign off now, and I'll go in the chat box to manage that. So over to you, Matt.
Great, good morning. Thank you, Kate, for that introduction. Yes, so this morning I'm going to be talking about the liberty protection safeguards, some light entertainment for us all this morning. And I've called the talk Liberty Protection Safeguards, Where Are We Now? I suppose the short answer to that is that we're in sort of an in-between phase where in the calm before the storm, albeit quite a long time before the storm, because I'm sure most people here will be aware that the latest news is that the actual implementation of the liberty protection safeguards has been put back till April 2022, which puts us in a somewhat strange position in that we have the Act, we have the outline of how the system's going to work, but we don't yet have the code of practice and the regulations, which are going to put a lot more meat on the bone. So it's hard to give detailed training on what the liberty protection safeguards will look like right now. And indeed, if we started giving out training now, of course, everyone would have, the best way in the world, forgotten about it by April 2022. But I do think that the position we're in now does give us a good opportunity to pause and reflect. And I do think in order to understand where we are now, it's also important to understand how we got here. And so what I'm proposing to do in the first part of my talk is to give a little bit of a history, a bit of a background and the context as to how we got here in the first place. I present it here in the form of effectively a timeline. But of course, life isn't really as straightforward as that. The actual path to how we got here today was a lot more complicated than this, but it's still helpful to think of it as a succession of events, a sequence of events, a narrative to help us understand how we got here. I've just had a message popped up saying that you can only see half the screen. I don't know if Kate, can you help me? Is that the same for everyone?
Yeah, it's looking as if it's chopped off. Maybe. Yes, that's perfect.
Right, and it's the whole thing, is
right.
It? Yeah, perfect.
Yeah.
Sorry about that. Right. Yes, excuse me, because I've just off to my left, but I'll try to look at the camera. Yes, I've presented here timeline as to how we got here today. I'm going to talk through it. I should mention also, I'm going to try and read out all the information that's on the slide. So those who are not able to actually read as we go along, you should be assured that all the information that's on the slides, I will be speaking it also. I don't know about anyone else, but one of the big things I've found has been a positive of the lockdown is the way in which we can get information via sessions like this, via webinars. And I've got into the habit of actually just putting it on my phone, putting my headphones on, and going out for a walk and just listening as we go along, treating it as a podcast. So if you are, I realise that might be possible for everyone. Other people might be, for various reasons, prefer to stay where they are. Yeah, so maybe there'll be people out there who are treating this as a podcast, as an audio-only format, and I'm going to try and make this so that it works in that format, so that all the information that's on the slide will also come out of my mouth at some point during the talk. So, to begin at the beginning, the story starts. I now can't change my slides because of the. Hang on a sec. There you go. Right. The story starts with the European Convention on Human Rights and Article 5, which sets out the right to liberty and security of persons. So, of course, the European Convention was something that came out of the aftermath of World War II, when the leading nations of Western Europe came together to say never again, and to lay down some fundamental set of rights which they could all agree on. And we have the European Convention, which eventually came into being in 1953, which set out rights such as the right to life, the right to freedom from torture and inhuman or degrading treatment, the right to a fair trial, to a private and family life, to freedom of expression, and so on. And crucially for us, as I say, the right to liberty and security. I'll pause here to say that, of course, we've got Brexit looming once again, or rather Brexit has happened, and we've got the next stage or the next phase of Brexit coming up. Just to be absolutely clear, the European Convention on Human Rights is a separate entity from the European Union. And just because we are leaving the European Union does not mean that we are leaving the Convention, or in any way the Convention will not apply to us anymore. I mean, it's fair to say that many of the people who were big fans of Brexit and in favour of Brexit are also not great fans of the European Convention, and there are noises coming out of certain sections of government and those associated with Brexit that the European Convention might be next, but for the present purposes, it is in force, it remains in force. We remain a signatory to the European Convention. I think the noises that are coming out of government around the European Convention and around the ability of people to challenge government decisions probably stem in large part due to members of the government being slightly annoyed at the Supreme Court judgment last year. Everyone will remember Baroness Hale, she of the spider brooch, and I guess it's no spoiler alert to say that Baroness Hale will be making one or two further appearances in this morning's session. So the European Convention, I'm not going to read things out laboriously, but I do think it's worth being clear what Article 5 of the European Convention says. The right to liberty and security. Everyone has the right to liberty and security of person. No person should be deprived of his liberty save in the following cases and in accordance with the procedure prescribed by law. And then it sets out a number of exceptions to that, situations where somebody can be deprived of their liberty, one of which, for our purposes, is the lawful detention of persons of unsound mind. Crucially, though, Article 5 then goes on to say that if somebody is going to be deprived of their liberty in one of those situations, they shall be entitled to take proceedings by which the lawfulness of their detention shall be decided speedily by a court and their release ordered if the detention is not lawful. So you've got the European Convention saying there's a right to liberty. It's accepting that there are certain categories of case where the state can deprive citizens of their liberty. The other ones, which are not relevant to today's purposes, are things like when you're convicted of a serious criminal offence or potentially on remand for a criminal offence, certain categories of immigration detention and so on. But as I say, it recognises in the language of the 1950s, which we might perhaps not use today, that it's possible to have the lawful detention of persons of unsound mind. But if that's going to happen, the state has to make available to the person the ability to challenge that detention speedily through the courts. So you then had the European Court of Human Rights setting out various laying out case law over the years, which further refined that definition of deprivation of liberty. The European Court, in various judgments, found that there were three elements that were required for a deprivation of liberty to be found. The first one is a person confined to a particular restricted place for a non-negligible period of time, and that's become known as the objective element of deprivation of liberty. Secondly, has the person consented, and can they consent, or can they consent rather, and that's become known as subjective element. And of course, for today's purposes, that's crucial because we're, for the large part, talking about people who are unable to consent to their confinement. And then finally, are the arrangements imputable to the state? In other words, is the state responsible for these arrangements in some way? And as we'll be hearing later on, that has been widened somewhat in some of the recent case law. And then when things, at the point where things really came to the crunch in terms of that definition of deprivation of liberty and how it was going to apply in our jurisdiction in England and Wales, with the United Kingdom generally, was this case of HL in the United Kingdom, which is the European Court of Human Rights case, and has become known as the Bournemout Case. I've put on the slide a link. I realise that's not terribly useful for people to click on right now, but if you Google the Bournemout Case or Bournemout Case summary, certainly when I tried this the other day, the first thing that came up was this link to the Equality and Human Rights website, which has a really fantastic set of summaries and examples and case studies of where human rights human rights cases and human rights law has made a real practical impact in the real world. And there's a really great video case summary of this Bournemout case concerning a man known as HL, who was 45 years old at the time of the events in question. He had spent 32 years living in Bournemouth Hospital, but in 1994 he went to live with a Mr. and Mrs. E in a local resettlement scheme, with the idea that he would be then able to live in the community, not in a hospital setting anymore. However, after a few years, he ended up getting readmitted to Bournemouth Hospital after an episode when he was being taken to his day centre and subsequently arrived at the day centre, and they were unable to manage the behaviour that he was displaying, and he was taken back to hospital. But once there, because he was not complaining, not resisting, he was compliant, he didn't resist his admission. The clinicians there decided to admit him as an informal patient in his best interests. However, Mr. and Mrs. E wanted him to come home. They were not happy with him being back at the hospital. They couldn't see why he needed to be there. And they eventually decided to take legal action to try and secure his return. I'll also pause again here just to mention, I'm referring to them as Mr. and Mrs. E. Mr. E, in fact, was a gentleman called Graham Enderby, who I understand from some information I've seen from Kate, was a friend of the Advocacy conference, and I think I might be saying right in front of you, he's a previous speaker here, who sadly passed away earlier this year. Another way to find out a bit more about the background to this is to read the really touching obituary that appeared to him in The Guardian in March of this year. He's a really remarkable man, and the saga of this court case is a real testament to him and to his family. So they took it to court. It's I say it's a saga, a very, very long saga through the courts in this country. Eventually, it went, well, first of all, it went through the courts in this country. The House of Lords and found in favour of the hospital and said that under a concept of the common law in this country called the doctrine of necessity, they'd acted lawfully under the law in this country. But Mr. and Mrs. E took the case to the European Court of Human Rights, and the European Court found that HL had been deprived of his liberty not in accordance with the law, that the law in England and Wales was not compliant with Article 5.4, and they particularly highlighted that there was no formal procedure to authorise, to say who was authorising the detention, no requirement to give reasons for the detention, there was no requirement for ongoing clinical assessment and review, and there was no procedure, there was no way of securing representation for HL, and they drew a contrast with the situation under the Mental Health Act that we'll all be familiar with, that if you're detained under the Mental Health Act, most people, regardless, I realise that there are people who have a particular interest in this area, but I think amongst the wider public there is an understanding that if you're detained under the Mental Health Act, there's a system in place whereby you can access legal aid, you can access a tribunal, there are forms you can fill in, there's a process, a procedure for challenging your deprivation of liberty in that situation. Whereas in HL's situation, in the Bournemout case, there was no such procedure put in place, and so the European Court of Human Rights found that the law in this country, as a result of that, was not compliant with Article 5.4. So, as a result of that, the government had to plug what had become known as the Bournemout gap. They had to come up with a system to make the law compliant. And the system they came up with was the Deprivation of Liberty Safeguard, a system we all know and love, he said slightly sarcastically. So the idea here was, as I say, it would be a procedure, it would be a system for lawfully authorising deprivation of liberty on behalf of people who lacked capacity in situations where it's intended to cover all situations where the Mental Health Act didn't apply. But the government, in its wisdom, created a system which only applied to people in hospitals and registered care homes. One can only assume that the idea was, or the assumption was, that was where the vast majority, if not all people who would be caught by these provisions would be placed. But as we all know, there are plenty of situations out there where people who are in a similar situation to HL was, but are not in a hospital or care home. And so the question arose about what happens in those situations, and that came to a head in the Supreme Court case of Cheshire West, which, as Kate mentioned earlier on, is a case I was involved in. I acted for the mother of P, who was the gentleman who was at the centre of the case. So as I say, this looked at the situation where someone was in supported living, not in hospital or care home, and it looked at that objective element of deprivation of liberty, the question of when is someone confined to a particular space for a non-negligible period of time. P, the man involved in this case, which came to court in 2014, he was 38 years old at the time of the initial proceedings, and he had cerebral palsy and Down syndrome, and he required 24-hour care to meet his personal care needs. The procedural background to all of this is somewhat more complicated. It's one of those awful situations which thankfully don't happen quite so often these days, but do happen from time to time, where he had effectively been removed from his mother's care, purportedly under a best interest decision, but with the local authority knowing full well that his mother objected to this, and knowing full well that they should have gone to the Court of Protection to seek authorisation for that removal. By the time it got to the Court of Protection, many months after the initial removal, we, acting on behalf of P's mother, accepted that at that point it was actually in his best interest to remain in the local authority accommodation that they'd put him in, which was a supported living placement. We argued, though, as did P's own representatives through his litigation firm, the official solicitor, that this new placement itself amounted to a deprivation of his liberty, and therefore, because it couldn't be authorised under the deprivation of liberty safeguards, it needed to be authorised by the Court of Protection, because there was no other way for a lawful authorisation to be provided. Again, cutting a very long story short, the Supreme Court, and this is where Baroness Hale, giving the lead judgment, makes her further appearance here, found that P's circumstances were a deprivation of liberty, and that as he was not in a hospital or care home, the arrangements failed to be authorised by an order of the Court of Protection, and Baroness Hale laid down what's become now known as the acid test for deprivation of liberty, namely, is P under continuous supervision and control, and not free to leave the placement. The court was also very keen to emphasise that certain factors were not relevant to the application of the test. It had previously been suggested that some of these things might be relevant, particularly in the Court of Appeal judgment, which preceded the Supreme Court judgment. So, for example, just because a person was compliant or not objecting to their placement, that's not relevant to whether they're deprived of their liberty. Just because the placement might seem relatively normal, might seem like a normal home environment, that's not relevant for deprivation of liberty. And I think we will all be familiar with the idea that you can have two buildings, you can have two placements, perhaps even next door to each other, which might look the same. They might have same building, it's effectively the same kind of, or the same, in practical terms, the same care being provided in them. But one is registered as a care home, and one is a supported living placement where the care is provided by a domiciliary care agency. So you've got the two, and they both might look relatively homely, but one falls under the deprivation of liberty safeguards regime and one doesn't. So just because something looks normal, that's not a factor to be taken into account. It's not a factor that would lead to someone being deprived of their liberty. And Baroness Hale also emphasised that the reason or the purpose behind a particular placement is not relevant just because it's in someone's considered to be all for the best or for the good of the individual. That in itself is not a reason to conclude that they're not deprived of their liberty. And she came up with this other famous phrase from the judgment that a gilded cage is still a cage. So that was the first. That was a change in the understanding of the definition of deprivation of liberty, which led to many more people being considered to be deprived of their liberty than had previously been the case. We also had, following on in the years after the Cheshire West case, further case law which would result in more people than had previously been thought being considered to be deprived of their liberty. One case, which is another one which, although I wasn't directly involved in, is another case that my colleagues at Owen Mitchell were involved in, called Staffordshire County Council and SRK, which involved a man who was being provided with care entirely through a privately funded care package. And the question arose there that if his care package, if his circumstances met the acid test, in that he was not free to leave and he was under continual supervision and control, did those arrangements, despite not being funded by the state, did they fall to be authorised by the Court of Protection? And the answer in this case, in the Court of Protection and subsequently the Court of Appeal agreeing, was that yes, in the circumstance of this particular case, notably that the local authority was aware of the fact that the state had had some involvement in appointing a deputy, the Property and Affairs deputy, who was effectively managing that care package. That did need to be authorised by the Court of Protection. The court, somewhat less helpfully, was less clear about what the mechanism would be and whose responsibility it would be to actually seek that authorisation. But the conclusion was very clearly that did require authorisation in order to comply with Article 5.4. Another more recent case, which is again widened or indeed, or at least clarified the scope of deprivation of liberty authorisations, is this case of Re-D, another Supreme Court case, another appearance by Baroness Hale giving one of the judgments in the case, in which the Supreme Court held that parents can't consent to a deprivation of liberty on behalf of a 16 or 17-year-old whose circumstances meet the acid test and who can't or don't give their own consent. So that's now meant that there'll be a whole category of people, 16 and 17-year-olds, who, although in some circumstances their deprivation of liberty could be authorised through the family courts, once they're approaching that age of 16, 17, they might potentially be continue to be deprived of their liberty beyond the age of 17. We're looking at authorisations needing to be provided via the Court of Protection. So, the cumulative effect of all of these things, the Bournemout case, then the Cheshire West case, and then these further pieces of case law that have come out over the years, is massive pressures on the system. It almost seems comical now that the original government impact assessment for DOLs estimated that there would be 20,000 DOLs assessments per year. And I suppose in fairness, prior to the Cheshire West judgment, the figures were around that figure, if not slightly lower than that. Whereas we all now know, and we've seen in some of the more recent statistics, that, for example, in 2018-19, the actual number of applications made was 240,000, and there has been a backlog and a growing backlog, and that that same point, 2018-19, there were over 130,000 applications which have not yet been completed. As I say, there's also all the cases that fall to be authorised outside of the DOL system. So the DOLs is the administrative paper-based system meant to not involve going to court, but all those people who are not in care homes and hospitals, but whose circumstances meet the acid test, their deprivation of liberty falls to be authorised by the Court of Protection. The statistics are a little harder to come by in relation to the number of cases going to the Court of Protection for authorisation, because they come in different shapes and sizes. Some of them are non-contested paper-based situations, some of them are more contested hearings. But we have, at one point last year, the court was reporting that there was a backlog of around 2,000 of those cases which have yet to have been dealt with. I understand that's got a lot better more recently. Again, one of the sort of strange benefits of the lockdown situation is that with judges working from home, they've been able to get through a lot more of those paper-based DOL authorisations rather. And at one point during the statistics last year, the court was reporting that for one quarter there were 900 applications for court authorisation of deprivation of liberty. Extrapolating from that, that might suggest that there were around just under 4,000 requests for court-based authorisations for deprivation of liberty. But I'm sure everyone will recognise that that must surely be just a fraction of the number, a small fraction of the number of people who actually require deprivation of liberty authorisation for their circumstances in a non-care home or hospital environment, for all those people out there in supported living and indeed all the other kinds of placements out there which don't meet the definition of care home or hospital. So there's a real unknown quantity out there. How many people really are there out there who ought to have an authorisation in place and are not counted in these statistics? So as a result of these increasing pressures, and particularly the bureaucratic burden of the deprivation of liberty safeguards, the government, the Law Commission was asked to go away and look at the situation and try and make some recommendations for reforming the law in this field. So the Law Commission is a body which does exactly that. It makes recommendations for improving the law, for reforming the law. It spent a lot of time, did a lot of work in coming up with a system or proposal for an alternative system to the deprivation of liberty safeguards. Though after publishing its recommendations and its draft bill, the government somewhat unaccountably swept away a lot, if not most, of what the Law Commission had recommended and came up with its own plan. Its own plan being intended to streamline, to make the system cleaner, to make it neater, to make it less bureaucratic, and to make it something that would be actually used in practice, and to try and tackle this backlog of authorisations that was building up. The scheme supposedly was meant to be cost neutral, or at least cost saving, and put a lot of emphasis on care home managers, which we'll be hearing more about shortly, though that has raised a lot of eyebrows in that the government really doesn't seem to have taken into account the additional time that the care home managers are going to potentially be taking on the new regime, and the potential additional time and cost that will be associated with that. So after somewhat bumpy passage through Parliament, it was finally became a bill. The Mental Capacity Bill became the Mental Capacity Act on the 16th of May 2019. And as I say, it was intended to address the substantial increase in deprivation of liberty safeguards cases and the many criticisms of the previous Dole's legislation. Although the Act doesn't actually mention the phrase liberty protection safeguards, that is what they've become known as, frankly, for want of a better name. So, what do the liberty protection safeguards do? As I say, at the moment, it's the Act, the amendment to the Mental Capacity Act is quite high level. It sets out the bare bones of the scheme. There's going to be a lot more detail, it is to be hoped, when the code of practice and the regulations are published somewhat later down the line. So one thing that's clear from the Act, though, is that there's not going to be any statutory definition of deprivation of liberty. It will be interesting to see, in fact, what the code of practice says about a definition of deprivation of liberty. It seems that the government and the scheme is going to be somewhat tied to the definition that we've already had under the Cheshire West case. But we might see some sort of tinkering around the edges. There's been, particularly in recent months, the government's put out some guidance on the definition of deprivation of liberty in the context of the COVID pandemic. And it might be that the government seeks to limit the definition of deprivation of liberty by adopting what was said in a case called Ferreira about urgent treatment situations and life-sustaining treatment, where life-saving treatment is being provided. It might be that people are not treated as being deprived of their liberty in those circumstances. The logic being that anyone in that situation is not really free to leave. They are simply receiving life-sustaining treatment that is absolutely necessary for them. Personally, I find it difficult when you sort of drill down on that definition to distinguish that from the other types of case that come up with. But as I say, it remains to be seen exactly how the government will seek to define deprivation of liberty when the code of practice comes out. The liberty protection safeguards will apply to individuals aged 16 and over, so that's one change, significant change from the previous Dole's regime, and that's something that was introduced as the new law went through Parliament. Under the new scheme, the local authority will effectively be the default responsible body for authorising the deprivation of liberty. In other circumstances where the arrangements are in an NHS hospital, it will be the hospital managers who are responsible for the deprivation of liberty. And where a person is eligible for NHS continuing healthcare and receiving NHS continuing healthcare, the CCG will be the responsible body for authorising the deprivation of liberty. I'll mention also that in the case of private hospitals, it's going to be the local authority that's responsible for authorising the deprivation of liberty, and indeed where there are private care arrangements. That point about CCGs and continuing healthcare, I may be being overly optimistic here, but it seems to me that might actually be an opportunity to provide more clarity for a lot of people, because certainly in my experience, and I expect for a lot of the people attending here today, there can sometimes be a complete lack of clarity as to the funding arrangements for a particular individual. It can even be that the statutory bodies, the local authority and the CCG themselves are unclear as to whether a person is actually in receipt of NHS continuing healthcare. And so if the question needs to be tackled at an early stage to actually establish who's going to be the responsible body, that might actually provide some welcome clarity for people on the ground to actually understand who's funding their care, and indeed, crucially for the purpose of lawyers and indeed advocates, actually knowing whose door to knock on to actually resolve issues, to actually address who's going to know who to complain to effectively where there's an issue about the care they're receiving. And crucially, the liberty protection safeguards will apply in all settings, so it's included supported living, family home, private care arrangements. So that's another crucial area where it goes much more widely than the previous deprivation of liberty safeguards regime. So that should mean it will ease the burden on the Court of Protection to provide authorisations, because the Court of Protection will no longer then be the default for providing the authorisations in those circumstances. The new scheme then says that the conditions that need to be satisfied before an arrangement can be authorised are, first of all, the person lacks the capacity to consent to the arrangement, that they have a mental disorder, and that the arrangements are necessary to prevent harm to them and are proportionate in relation to the likelihood and seriousness of the harm to them. First thing to note there is that during the course of the passage of the new scheme through Parliament, the wording there was changed from a person having unsound mind, which was reflecting the language in Article 5 that we looked at earlier, to the somewhat more modern, he has a mental disorder. Under the new scheme, there is provision for reliance to be placed on earlier assessments if it's reasonable to do so. So there's that's one of the ways in which the government is hoping that the new system could be more streamlined and less onerous in terms of the assessment process. It should also be noted that this test is different to the one under deprivation of liberty safeguards, which also has best interest as a factor. So the deprivation of liberty safeguards, the old or current rather regime, also has, in slightly different wording, but effectively the same concept of necessary and proportionate, but also has best interest, whereas the new test doesn't have that wording of best interests. Now, you might say that in practice, it might be difficult to think of situations where the outcome will be different by removing that best interest test. But I do think it's fair to say that there's going to be a shift in emphasis that does result in a shift of emphasis. We really need to be asking ourselves, are these arrangements, are they really necessary and proportionate? That if you remove the best interest test, it is a slightly different way of looking at the situation. And that's something that we can perhaps, because it is also a part of the current test, it is something that we can start doing already, really starting to think when we're looking at this question as to whether it's really necessary and proportionate. So another factor in the new regime is that a pre-authorization review must be carried out by someone who is not involved in the day-to-day care to determine that these three conditions are met. There's also provision for the challenge report to the authorization by the Court of Protection under a new section 21ZA, which is a real mouthful. many of us will be used to hearing about Section 21A cases. I really find it hard to believe we're going to be going on and on about Section 21ZA cases in future, but I guess that's the new reality we're going to have to deal with. The Act doesn't talk about legal aid, but the government has separately confirmed that non-means tested legal aid will continue in much the same way as it currently exists for Section 21A cases. The new regime also says that the responsible body must consult with the person. Surprise, surprise. I mean, somewhat surprisingly, that wasn't entirely clear from the early versions of the new regime, but it is clear now the person must be consulted with, as must indeed persons who are interested in the person's welfare. So very similar to the concept under the existing Mental Capacity Act best interest decision-making process. If the person is objecting or appears to be objecting to their placement, or if they are in a private hospital, then the person carrying out the pre-authorization review must be an accredited mental capacity professional, a role which is going to be very important under the new regime. And the authorization under the new regime in the first instance can be for up to 1 year, but thereafter it can be for periods of up to 3 years. So that's another departure from the current regime, whereby it's up to a maximum of 12 months. And that would be interesting to see how that works in practice and whether that will in fact really afford protections that people currently have, albeit that you can see that by having authorizations for up to 3 years, that presumably the government's intention there is to try and reduce the burden of ongoing annual reviews. Under the new scheme, the authorizations will be portable if that's been anticipated in advance, which means that they can follow the person from placement to placement, as long as that has been flagged up in advance, and they can cover more than one environment. And crucially, as part of the system, the person who's being cared for will be supported by an appropriate person, or where there's no suitable appropriate person, by an IMCA for the duration of their authorization. Now, it's not possible really to talk in terms of comparing the current system like for like with the LPS system like for like with the Dole system, because the whole structure is so radically different. You can't really talk in simple terms as to this is the equivalent of that. But as far as possible, you could say that this appropriate person, and particularly the IMCA role of appropriate person, is roughly analogous to the current RPR, relevant persons representative, and the paid relevant persons representative under the existing scheme. It will remain to be seen whether the trend that we've seen of local authorities appointing more and more paid RPRs following some of the earlier case law under the Mental Capacity Act will continue. We have then this interesting provision that the government's introduced, whereby if the person is aged 18 or over, and the proposed arrangements will be carried out wholly or partly at a care home, then in that case, the responsible body can decide if it will arrange the necessary assessments, or whether they will ask the care home manager to do so. Again, this presumably is the government thinking, having the thought process that they could make cost savings by passing it all on to care home managers, of course. Well, it remains to be seen whether really that would be appropriate, because there have been some criticisms of the existing, the proposed new regime. So the idea that care home managers will be carrying out the assessments of, or will be leading on the assessment of capacity and on the question of necessity and proportionality, and passing their findings on to the local authority, that has raised a few eyebrows. And there's potential conflict of interest there, one might say. Is the care home manager, do they potentially have an interest in people remaining within their facility? Though it is clear that these arrangements can't be undertaken by someone who has a particular prescribed connection. One thing that's particularly troubling, I think, is that there's going to be emphasis on the care home manager looking at whether the person is in fact objecting, and I find that I do think that's going to be something that the courts are going to be interested in looking at, because even in the best of circumstances, even those of us who deal with these things day in, day out and have a very detailed understanding of how the system works, I mean, I confess I find that question of whether a person is objecting to be troubling and not always easy to understand. And I think putting that in the hands of care home managers is potentially a recipe for trouble. And there's that's putting aside the question of whether the care home managers, who, let's face it, are very hard pressed already and have a million and one other things on their plate, whether they have the level of expertise to carry out these assessments. So I would expect that there may well be some cases earlier on in the advent of after April 2022, which look at this particular question. I think that's going to be one of the crunch points, and it may well be that that local authorities, well, maybe they might even decide to be cautious, and because they've actually got the choice whether or not to ask the care home managers to carry out these arrangements, they might just take the path, the cautious path, and actually decide to not to ask the care home managers to do these things and to do them themselves. As I mentioned already, this question of authorisations being possibly for up to 3 years, that has potentially a cause for concern. The 3 years is, of course, a long time. It may well be something that comes for challenge later down the line. As I've been saying repeatedly, there's a lot to come out still in the code of practice. The devil will be in the detail, and we're not going to hear much about that for a while. I mentioned already this new role of the appropriate person. I mean, I do think that they're potentially going to be the engine for challenges, as it currently, in the majority of cases that are coming to court under Section 21A, it's because the RPR, very often the paid RPR, has taken steps to ensure that the case has got to court. I think that's going to be, under the new scheme, it's going to fall in large part on the appropriate person, particularly the IMCA, acting as effectively a paid appropriate person. The provisions for appointing an IMCA say that it's limited to where it's deemed to be in a person's best interests to be supported by an IMCA. So it's not automatic, and that does slightly worryingly leave an element of discretion as to whether an IMCA is going to be appointed. I mean, you might think that it's always going to be in a person's best interest to have an IMCA. I mean, how can it not be in a person's best interests? And so the optimist in me says that, well, it'll just be more or less automatic. The IMCAs will be appointed in virtually all of these cases. But there is that nagging doubt that there is a possibility there that does leave open the door for decision makers to decide, or actually, no, we're not going to appoint an IMCA in this case. And, again, I can see potential problems emerging later down the line in relation to that particular provision. I'll also mention that this is going to mean that the contractual arrangements will be up for review in relation to the current paid RPR arrangement. You can expect over the coming year and a bit, until April 2022, there is an opportunity here to look at the existing arrangements and to make the appropriate arrangements to reflect that there's going to be this new paid appropriate person role coming in, which is eventually going to supplant the paid RPR role. Those of you out there who will be involved in those discussions with local authorities, I would want to sort of see if there is an opportunity there to clarify with local authorities that perhaps sometimes at the moment those contractual arrangements are not making it clear enough that it's very much part of the paid RPR's role to ensure that cases are being brought to court in appropriate cases. I think there's sometimes a tendency to think that a case going to court is a failure and is a down mark. It really should be a good mark. It should be a positive. It seems to me that it should actually be a sort of key performance indicator that if cases are going to court, that assignment system is working, that the advocate or the RPR is doing their job properly. And so I'd like to see in these discussions that are going to be taking place over the next 12 plus months before the scheme comes into place, an acknowledgement and a working together between the advocacy organisations and the local authorities to recognise that part of the system is that cases are going to court, and that is an appropriate thing for the appropriate person to be doing. And indeed, in certain cases, that the appropriate person could indeed act as a litigation friend, as the RPRs do in many cases under the current system. So, as I mentioned at the outset, we all thought this was going to be in effect by now. It was meant to be in effect by October of this year, but of course, there's been one or two events out there which have caused many things to be delayed. We've now had the announcement, the announcement was in July, that it's going to be delayed until April 2022. More recently, in September, the government has set out a bit more detail about the timeline for implementation, so that we now know that there's going to be a 12-week consultation on the regulations and the code of practice, which will take place in spring 2021, spring of next year. And the government also announced that as part of that, they're going to be looking at consolidating the code of practice. So there's effectively going to be an updated code of practice to the Mental Capacity Act, which will then incorporate a single code of practice for LPS and the Mental Capacity Act. And that's a really big opportunity for all of us to feed into the consultation process, to say what we would like to see in a new, updated Mental Capacity Act code of practice. One thing that we might want to suggest, and I'm sure everyone will have their own views on this, is making it very clear the process for appropriate persons and indeed IMCAs in non-LPS cases to refer cases to the Courts of Protection, making it clear that not only is it possible to do that, but it is actually the right thing to do, and that IMCAs can refer cases to the Courts of Protection either as a litigation friend or in their own right. And also, I mean, my own bugbear with the existing regime is that, to my mind, it doesn't really emphasise enough the need for consultation in the general. I'm talking not specifically about the LPS here, but about the Mental Capacity Act generally, in the best interest decision-making process. I don't think it's nearly clear enough that the best interest decision-making process involves consultation with friends and family, and that if the friends and family are not in agreement with the course of action that the decision maker is proposing or deciding upon, then in very often requires the decision maker, the public authority, to refer the case to the Court of Protection. I would like to see a new code of practice being much clearer on that point. But I could go on all day about amendments to the Mental Capacity Act, but that's a topic for to the code of practice rather, but that's a topic for another day. I'll just mention very briefly, I mean, I've talked about the impact of COVID-19. Of course, the biggest impact has been to cause much delay on many things. Very early on in lockdown, Mr. Justice Hayden, who's the Vice President of the Court of Protection, put out a letter emphasising the importance that the system must carry on. I mean, the government has been clear that the Mental Capacity Act and the DOLS regime have not been amended by the coronavirus regulations. They are still in effect. And Mr. Justice Hayden said in his letter that whilst he recognises that parts of the system are under great strain in this national emergency, the need for rigorous protection of the rights of the incapacitous is not in any way diminished. If anything, the increased vulnerability and isolation, which are the characteristics of this viral pandemic, requires scrutiny on the basis of any deprivation of liberty to be both scrupulous and vigilant. So this is Mr. Justice Hayden, Vice President of the Court of Protection, saying this pandemic is not an excuse for lowering the safeguards, for fewer safeguards. If anything, it means there needs to be more safeguards, more vigilance, more scrutiny. Again, it's not something I can go into in detail now, but the government, as many of you will be aware, has issued guidance on the operation of the Mental Capacity Act and the deprivation of liberty safeguards during the course of the COVID-19 pandemic, and was recently updated on the 15th of October, again emphasising that the MCA and DOLS remain fully in force, and giving some practical guidance on the appropriateness of remote assessments, and more recently on how assessments.
Sorry?
How long are you going to be on this?
Another 5 minutes.
Emphasising the practical guidance on the impact on local restrictions on contact. And so finally, the other thing to note from the government in terms of how this is going to all transition is that the government expects that those who are subject to deprivation of liberty authorisations under the current DOLS scheme will those DOLS authorisations will remain in force at the date of the handover, as it were, in April 2022, and that further guidance is going to be coming out during the course of the code of practice and the regulations on the exact format of that transition from the old regime to the new regime. But we can assume for the moment that all those DOLS authorisations which are in force in April 2022 will continue to remain in force until their sort of natural life expires. And a very, very final point before we move on, if you've got any time for questions, there's a link to a website here, Mental Capacity Law and Policy, which is operated by Alex Lutch-Keane, who many of you will be familiar with, which is a really fantastic resource for all things related to mental capacity law and indeed liberty protection safeguards updates. So I'm conscious I've only left a short time for questions, but I'm very happy to do that. If Kate, I don't know, I can see lots and lots of things have been popping up on the screen as I've been talking. I don't know if there are any themes emerging, Kate, that you want me to tackle now, or by all means we can take things offline as well.
We can get a couple. I've made been putting things in kind of buckets. So a nice quick one is any news on the legal aid regulations?
So we haven't got anything concrete other than an assurance from the government that my reading of what the government has said is that the same situation will apply as currently to Section 21A cases will apply to this new Section 21ZA challenges. The slight caveat to that, though, is that the new regime has a slightly different concept to urgent authorisations, whereas at the moment you can get legal aid when there's an urgent authorisation in place. Under the new scheme, there's going to be basically a certain amount of leeway in the early days whilst an authorisation is going through for sort of for urgent authorisation, or the equivalent of urgent authorisation. It's not clear to me at the moment that by saying that legal aid is available for the Section 21ZA cases, that will in fact mean that legal aid is available for those urgent challenges at the beginning of someone's detention. So that's another matter for further discussions with the government and the powers that be, and in particular the legal aid agency. Got you.
Thank you. Some comments around hospitals using dolls or not using dolls appropriately, and a general lack of understanding. What are your views on whether the LPS will improve things or not touch it?
Well, I mean, first of all, it's fair to say, and I agree with those comments, that sadly, I mean, I think, the world of social care has come on leaps and bounds from, I talked about how in the Cheshire West case there was, shall we say, some mistakes made by the local authority in that case in terms of non-compliance with the Mental Capacity Act. But cases like Cheshire West and some of the others where local authorities have had their fingers burnt, to put it mildly, have meant that there has been a massive improvement in the understanding of the Mental Capacity Act in the field of social care. Sadly, that's not always been the case in the field of healthcare. I think it's fair to say that hospitals, we've all come across, I'm sure, situations where hospitals don't even seem to understand the concept of the Mental Capacity Act of best interest. I think this new emphasis on the role of hospital managers, I mean, that's really got to make them sit up and pay attention. They're really going to have systems in place. So, the optimist in me says that that will, because we're starting again, this is an opportunity to try and get right what we didn't get right last time. And, I include myself in that. We've all got a responsibility here to try and share knowledge and share best practice in these things. And so we all need to be going out there and telling our colleagues, friends, contacts in the world of healthcare, hospitals, that this is coming. You need to know that this is coming. You need to know that you've got responsibilities. Your organisation has responsibilities into this. And you've now got this opportunity in these months ahead, before April 2022, to get up to speed on it, and make sure that you know what's going on, make sure you know what you need to do, make sure you've got a system in place in time for when it comes into force.
Yeah, thank you. Quick one around, currently legal aid is available for Section 21 appeals, but not for supported living doll appeals. Will LPS make it available for all?
Well, first of all, just to sort of correct or clarify that question, legal aid is available for non-Section 21A cases, for deprivation liberty cases in the community and supported living, but it's means tested. I think that's probably what the question means. Yeah. It's means tested, which means that sometimes if someone has capital, if they own the property, or if they've got savings over a certain amount, they won't get the benefit of that means tested legal aid, or indeed in some situations where the local authorities are managing their benefits, they might have accumulated benefits over the £8,000 capital threshold. I mean, that shouldn't be happening. The benefits should be managed better than that. But the short answer is it should, subject to the caveat I mentioned earlier on, that it's possible that in cases where the new system of urgent authorisations in place, there might be people who fall outside of that non-means tested legal aid. But the short answer is it should be better under the new scheme, that yes, non-means tested legal aid should be available for challenges to people who've got an LPS authorisation and are living in supported living.
Thank you. And Ferreira, I don't know if Peter, I don't know if you're able to unmute yourself, but there was a little discussion in the chat box around Ferreira, and oh, here he is.
Yes, I saw that at the corner of my eye. So thank you to Peter for doing the things that I was talking about. But yeah, the Ferreira judgment. I don't know what Peter's take is on it. I've personally found the Ferreira judgment a bit difficult to get my head around, to put it politely. But it's out there. It is the law, and the government, I think, is going to try and. Well, my best guess is that the government's going to try and incorporate that into this new definition of deprivation of liberty. Though. Question mark over how much that really is going to narrow down the number of people who are caught by this in practice.
Did you want to come in, Peter?
Well, only that the guidance that's been the COVID guidance on deprivation of liberty is one of the factors that led to a dramatic reduction on applications for standard authorisations. And the government clearly see this as the Ferreira judgment as an opportunity to argue that people in care homes, well, that's life-saving treatment, life-saving care, so it's not really a deprivation of liberty, is it? And to me, it's sort of symbolic. The two gateways in to making liberty protection safeguards work, and we're all going to try that, are, as Matt said, how do you identify who is objecting? And in a sense, it's a representative of the state that does that. And the state appears to be then giving guidance that what looks to everybody else like a deprivation of liberty isn't a deprivation of liberty because it's life-saving, and therefore you don't even need to authorise it. And my final point is that I just don't see how they can square any of this with the United Nations Convention on the Rights of People with Disabilities. But that, as they say, is another matter.
There's a whole other talk on that, Peter.
Yeah, fair enough. I'm really conscious of time, but there was a quick question around the code of practice, and do you think that the RD case will kind of make it into the code of practice?
I hope it will. I mean, it's up for grabs. It's up to all of us. I mean, I really would massively encourage everyone here, all the advocacy organisations, to feed into that consultation. We've got a real opportunity here to shape the code of practice when it comes out. And yes, I very much hope that the RD judgment and the AJ judgment, which I alluded to earlier on, which talked about the importance, or the situation where a non-paid RBR, where a family member RBR might in fact have a conflict of interest. They might have interest adverse to the person they're supposed to be representing. Those same factors, more or less exactly the same scenario, could apply to the appropriate person. And so, I very much hope that the code of practice will reflect the guidance that came out from those cases of RD and AJ. If it doesn't, then we're going to have to be going back to court and inviting the courts to basically make the same judgments again, or indeed just to say that all the previous Mental Capacity Act involves case law that's previously gone through the courts applies equally applicably to the new regime.
Thank you, Matt. Well, I'm sorry that I haven't been able to get through all the questions, but I'm going to call it there just because of time. Our next session is what we're calling an open water cooler chat. An open water cooler? No, a water cooler open chat. I get my words in the wrong order. Essentially, we're going to do a Zoom meeting where we can go to breakout rooms to kind of reflect on what we've heard today, talk as a community around our feelings about LPS and our concerns and our hopes really for what it can be. So I'm just popping, oh sorry, I just sent that to one person then. I'm going to pop the link in for the next meeting. So all are welcome to that. But yeah, huge thanks, Matt. So nice round of applause on behalf of everyone. Woo, 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 woo. And yeah, thanks very much everyone for contributing and being part of the discussion. There's been a couple of requests for the slides, so maybe we could, is that okay?
Absolutely fine by me, yes.
Well, it's interesting asking somebody publicly like this. The pressure is immense.
No, that's all fine. I assumed it was happening anyway. So.
Tip for advocates in the power of asking good questions and when. All right then, well thanks everyone so much, and thanks again Matt, that was
You're welcome. Thank you for having me. Thanks for listening everyone.
All right, take care, see you soon guys.
Thanks.
Bye.
Bye.